Yusin,
Clifford Theodolic, Xiao Jiazheng,
Hui Bin Hao, Lim Wei Jie. 1, 2. Judicial precedent is the source of law where past decisions of the judge create law for future judges to follow. The source of law is also known as case law. Judicial precedent remains a major source of law today. The level of the court making the decision is important when considering whether courts have to follow it. Precedent is based on the principle of stare decisis, meaning let the decision stand. This supports the idea of fairness and provides certainty in the law. A judge will give a summary of the case, review arguments, and explain the principles of the law he used to come to the decision in a judgment. The principles are an important part of the judgment and also known as the ratio decidendi, meaning reason for deciding. That is what creates a precedent for judges to follow in the future. An example of ratio decidendi is the neighbor principle in Donoghue versus Stevenson. The Latin term obiter dicta means things said by a way and is generally additional opinions of judges of hypothetical situations. It forms the remaining part of a judgment, and judges in the future cases do not have to follow it. For example, Lord Danning's obiter dicta statement in Central London Property Trust Limited versus High Trees House Limited. Binding precedent is a precedent from an earlier case that must be followed even if the judge in the later case does not agree with the legal principle. A binding precedent is only created when the facts of the second case are sufficiently similar to the original case and the decision was made by a court that is higher in the hierarchy of courts. Persuasive precedent is a precedent that is not binding on the court, but the judge may consider it that it is a correct principle, so he is persuaded that he should follow it. Persuasive precedent comes from a number of sources. Decision of lower courts may form persuasive precedent. This can be seen in the case of R versus R, where the House of Lords agreed and followed the decision of the Court of Appeal in deciding that a man could be guilty of raping his wife. In this case, the judgment of Court of Appeal was persuasive and House of Lords decided to follow it. Decisions of the Judicial Committee of the Privy Council can also form persuasive precedent. Since many of its judges are also members of the Supreme Court, their judgments are treated with respect and may often be followed. Decisions of courts in other Commonwealth countries such as Canada, Australia and New Zealand can also be taken account by UK courts. When a case has been decided by a majority of judges, the judge who disagreed will have explained his reasons. If the case goes on to a more superior court, it is possible that the more superior court may prefer the dissenting judgment and decide the case in the same way. The dissenting judgment has persuaded them to follow it.
Following the hierarchy of the courts, every courts are bound by the decision made by courts higher than them. In the hierarchy of the civil courts, the European Court of Justice is the highest court, followed up by the Supreme Court, then the Court of Appeal civil decision, then the High Court, and lastly the County Court. As for the hierarchy of the criminal courts, the Supreme Court is the highest court, followed up by the Court of Appeals criminal division, then the High Court, then the Crown Court, and lastly the Magistrate Court. The magistrates and the County Court are the lowest court in the criminal and civil division. These courts are bound by the decisions of the High Court, Court of Appeal, and the Supreme Court, which was previously known as the House of Lords. The Crown Court is bound by decisions of the Court of Appeal and the Supreme Court. The magistrates, county, and Crown Court are known as the inferior courts. The decisions made in the High Court are binding upon all inferior courts, but not upon other High Court judges, although in practice they rarely go against each other's decision. All Court of Appeal and the House of Lords decisions are binding upon the High Court. The Court of Appeal are bound by its own decision and the House of Lords. The European Court of Justice is the highest court in the civil courts, and the lower courts are bound by the decisions made by it. Decision made by the Supreme Court is binding on all other courts and itself. This was established in London Street Tramways against London County Council to ensure certainty in the law. It was soon realised that the final Court of Appeal should have more flexibility. Therefore, in 1966, the Lord Chancellor issued a practice statement announcing a change in the rule in London Street Tramway case. The practice statement states that the House of Lords are able to depart from a previous decision when it appears right to do so. The House of Lords was, however, reluctant to use this power in the first few years after 1966, as seen in Jones against Secretary of State for Social Services. The House of Lords refused to use the practice statement just because the earlier decision was felt to be wrong. In Conway against Rimmer, the House of Lords overruled its previous decision in Duncan against Camel on discovery of documents and held that the minister's affidavit was not binding on the court. It is the court who will decide whether such documents were to be disclosed or should public interest immunity be upheld.
The first major use of practice statement did not occur until 1972 in Harrington versus British Railway Board. Here, the court overruled that Eddy and Sons versus Dunbar, where it was established that common humanity test applied into whether the occupier has done all that a human person would have done to protect the safety of the trespasser. More recently, the court overruled Ents versus Merton London Borough Council on the common law liability of local authorities for the inspection of building foundations. Murphy versus Brentwood District Council unanimously overruled Ents' case on the basis of this was the reluctance of English judges to provide a remedy in tort for pure economic loss. Furthermore, in the case of Pepper versus Harts, the House of Lords declined to follow dicta in Bestwick versus Bestwick, Black CLAWSON'S case, and Davis Johnson on the use of HANSARD as extrinsic aid to the interpretation of statutes. Being free of the shackles of binding precedent, the House of Lords is uniquely placed to develop English domestic law through its judicial decisions. A momentous case can be seen in R versus R, where the House of Lords abolished altogether a husband's 250-year-old immunity from criminal liability for raping his wife. Their lordships justified the decision on the basis that the case was not concerned with the creation of a new offence, but with the duty to act in order to remove from the common law a fiction which had become unacceptable, per Lord Keith. The House saw the decision as an example of the ability of the common law to evolve in the light of changing social, economic, and cultural developments. Some commenters have viewed the decision in R versus R as coming close to usurping the lawmaking function of Parliament. The two subsequent cases, the House declined to change the law on the ground that doing so was the province of Parliament. The first case was R versus Clapp. It had been argued that the House should make new law by creating a new qualified defence which would have the effect of reducing murder to manslaughter. Lord Lloyd declared that he had no doubt that they should abstain from lawmaking in the present case, since the reduction of murder to manslaughter in a particular class was essentially a matter of Parliament, and not for them as a court to decide upon. Also, in Crown versus Director of Public Prosecution case, the House refused to abolish the presumption, preferring instead to call upon the Parliament to review it. R against G and R, two boys aged 11 and 12 was convicted of arson, the judge having ruled that recklessness was based on the risk obvious to a reasonable person rather than a typical 12-year-old. The Court of Appeal dismissed the boy appeal. The decision in R versus Cadwell had been much criticised, they said, but it was made by the decision of Lords and is thus binding on the Court of Appeal. The decision was subsequently reversed by the House of Lords, who depart from their own previous decision in Cadwell. The recent case of Alston against Mayor and Burgesses of the London Borough of Southern Park demonstrated, first, that Practice Statement 1966 applies to the Supreme Court, and second, that Supreme Court will be cautious about overturning an earlier decision on statutory interpretation, unless there are very strong reasons for doing so. The case concerned the interpretation of Section 82, Subsection 2 of the Housing Act 1985, which had been dealt with by the House of Lords in Knowsley Housing Trust versus White. Lord Hope in Austin versus South Park felt that Section 82, Subsection 2 was capable of being interpreted in different ways, but said that the question was whether it would be right for the Supreme Court to depart from a previous decision of the House of Lords. Lord Hope held that he was not persuaded that the Supreme Court should depart from the decision of the House in Knowsley, since the effect of reversing such a decision which had stood for so long was incalculable in this circumstance.
Following judging's points, the Court of Appeal is divided into Civil Division and the Criminal Division, which are bounded by decisions from the Supreme Court. It is binding only in the respective divisions, and there are instances where the Court of Appeal attempted to depart from the restrictions of stare decisis under the guidance of Lord Denning. However, the House of Lords strictly reinforces their binding decisions on the Court of Appeal, stating that the nature of the precedency should be followed. Such strong implementations was imposed in cases such as Milangos against George Frank Textile Limited concerning debts, and Broom against Cowell concerning exemplary damages, and the controversial writer David Irving. For Civil Division, the case of Young against Bristol Airplane Co. Limited set out 3 exceptions for departure from the precedent, which includes number 1, previous decisions made per incurrum. This was interpreted in R against Cooper, Duke against Reliance System, and Williams against Facet. The second one will be 2 conflicting decisions, which was then interpreted in Tiverton Estates against Warnwell. Lastly, there is a Supreme Court decision which effectively overrules the Court of Appeal's decision and interpreted in Family Housing Association against Jones. Lastly, the proposition of law that does not subject to consideration due to the case of R against Brentborough Housing Benefit Review Board. Next, we have the Criminal Division, though adheres to similar guidelines as the Civil Division, takes a more flexible approach where they are allowed to deviate from their own decisions if it is strongly believed that it involves the individual's liberty. For example, R against Spencer and R against Gold. The exceptions in Young's case also apply in criminal decisions. The House of Lords further reaffirmed its stance for the application of doctrine stare decisis when the Court of Appeal once again set out to widen exceptions in Gelly v. Lee. In addition to that, a leapfrog appeal is where there is an exclusion clause bypassing the procedure of a case, going to the Court of Appeal, and enables it to reach directly to the Supreme Court. It is permissible under the Administration of Justice Act 1969. The case must involve a point of law concerning a matter of general public importance, relating to a statutory instrument or an interpretation of a statute, or where a judge requires further clarification bound on a previous decision by the Court of Appeal, to which all litigants must consent to. The applicability of such cases only applies to civil cases. Flowing down the hierarchy, the High Court is next. It is bound by the decisions adjudicated by the House of Lords and subsequently the Court of Appeal. Similarly, its individual decisions are binding on the courts inferior to them, but not binding on the other High Court judges, even if they are strong of persuasive authority. Thereafter, the Crown Court is unable to create precedent, and their decisions cannot amount to more than persuasive authority, even if the hierarchy is subject to precedents bound from the superior courts. Likewise, the decisions of county courts and magistrates' courts are never binding.
Based on the previous facts that was mentioned by Yixian, we now know what judicial precedent represents, as there are many advantages and disadvantages of the doctrine of judicial precedent. And among the advantages are the consistency that is achieved between cases through the use of the doctrine. As cases with sufficiently similar material facts are bound by past decisions, it provides an idea of how the case will be decided. This strengthens the system and is also likely to reduce crime, since those who are aware of the consequences will be less likely to commit a criminal offense. Besides, it also provides a certain amount of certainty and fairness when the courts are using precedent. That is because the system provides fairness and justice, as similar cases will be treated and decided in the same way as a past case. This allows lawyers to advise their clients with some certainty as to their position and whether to take a case to court. Judicial precedent also avoids the waste of judicial effort and time rethinking about solution to similar problems that have been previously settled. A court is already provided with an answer to a problem in which they faced. It will not take as much time to reach a reasoned conclusion. For example, How effective judicial precedent can be is exemplified in the case of HANSARD and others, the Canary Wharf Limited and London Doctrine Development Corporation. Here, the court did not have to form an original precedent and could merely apply a previously established principle to the issue at hand. Besides, the existence of a judicial precedent may also prevent a court from making a mistake, as guidance will be provided as to how a case ought to be dealt with. Therefore, a judge will be less likely to make a mistake when reaching a conclusion, and a decision will be deemed to be a lot stronger. It will make it difficult for a court's decision to be contested, as there will be case law in place that will back up the court's decision, as shown in the case of Cartham v. Brent London Borough Council. This is important in preserving the integrity of the justice system and maintaining the judge's confidence.
Introduction of the practice statement ensured that flexibility was restored in the development of the law. The doctrine of judicial precedent gives a form of flexibility, as when there is room for change in the Supreme Court, they can use the practice statement that was mentioned earlier to overrule cases, and the ability to distinguish case also gives courts some degree of freedom. In the case of R against Brown and R against Wilson, is an example where the courts used methods of avoiding precedent, so they had flexibility to develop at the same rate as society changes. Precedent also provides a time-saving element, which in the long run saves money. And furthermore, judicial precedent avoids arbitrariness in judicial decisions during determination of cases. Lastly, judicial precedent preserves the tradition of compliance and respect in the judicial system, as the higher court has the power to correct or reverse the decisions of the lower court. On the flip side, there are also many disadvantages to the doctrine of judicial precedent. Among them are the rigid approach that is often criticized as one of the doctrine's main disadvantages due to the fact that it creates inflexibility. As courts lower down the court hierarchy, they are bound to decisions made by courts higher than them. Any bad or unjust decisions made would have a knock-on effect, as they are bound to follow them. In defense of this, the House of Lords are able to depart from past decisions in order to amend unjust decisions made by means of the practice statement. However, few cases actually reach the House of Lords, meaning that it is down to the other courts to decide the cases. And although precedent is seen as being consistent, it also brings complexity to the law. Seeing as there are millions of cases decided by court, it is often difficult to find relevant past cases. Application of a wrong past decision could lead to an unjust decision being made in a latter case. The law also becomes complex, as previously discussed, when cases are distinguished and a new precedent is formed. This is demonstrated in the cases of R against Caldwell and R against G, which later made the decision in Elliott against C very complex. Now, I'll pass the next disadvantage to Clifford.
The next disadvantage is it is often said that the doctrine introduces unnecessary restriction into the law. Because of the fast pace at which society advances, it is necessary for the law to keep abreast with any changes that are made. However, the existence of judicial precedent often prevents judges from developing legal doctrine in accordance with societal developments. This demonstrates how the judicial system is somewhat outmoded as reliance upon dead case law decisions will be made. This may not be appropriate in modern society, and it seems as though further advancements may need to be made. This has a negative impact upon the role of judicial precedent and highlights the complexity of the system. This is because a certain area of the law may have been developed over time, yet judicial decisions may not reflect the changes that have been made. Next, Pinhao will be talking about another disadvantage.
Furthermore, judicial precedent focuses more on compliance with precedent rather than the quality of law and decision that it discharges. The last disadvantage of the doctrine of judicial precedent is that it is fraught with restrictions. Judicial precedent is stereotyped in practice, and this weakens the power for judicial independence and accountability among courts.
In conclusion, the junior courts are bound by the decisions made by the senior courts to promote coherence, clarity, and predictability. We fully agree with this statement because of the points discussed above. So, 3, 2, 1.
Thank you, Miss Putri.
Happy Deepavali!